Hello, everyone. So there's a lot of news regarding the Supreme Court um, cases and also the fact that Justice Kennedy is now resigning. So this shows to me how elections matter. And I was saying for the longest time that I'm voting for Hillary Clinton for the Supreme Court. That's like my number one reason because of the impact that they have on case law in this country, and the effects of that are going to be very long lasting for decades to come. And we're seeing a lot of these 5-4 decisions come out of the court because Neil Gorsuch is on there, who was appointed by Trump. But Obama was trying to nominate Merrick Garland, um, and the Republicans successfully blocked them from even having a hearing about Merrick Garland. Um, and a lot of people are saying now that Kennedy is retiring, um, Obama nominated Merrick Garland, I believe it was some like 230 odd days before the election, the 2016 election, and Mitch McConnell then said, "Oh, we can't have Supreme Court nominees in an election year." That was their line of thinking, which was really just an excuse to not uh, have another Supreme Court pick from Obama. But now that Kennedy's retiring, it's 162 days, I believe I read, until the 2018 midterms. So a lot of Democrats are saying we should abstain and adhere to the rule that Mitch McConnell set. Well, I mean, in this case, I would say, yeah, doing everything you can to block another far right justice is is a good thing in my opinion. I mean, it may sound partisan because like I wasn't in favor of it for for when Mitch McConnell did it to Obama. I mean, at the same time, I feel like it was just disingenuous. Like they were making up this standard that like it can't be in an election year. So I don't know. Maybe they put that more on themselves. Like they set that standard, so now maybe we should try and follow their advice. Um, yeah. But I could see why that would seem partisan, but I feel like I'm just honest about the fact that I want progressive policies, so I don't necessarily have to adhere to like following to like having like that same standard. I don't know, but regardless, so there's a lot of 5-4 decisions that come out of the court. Um, I want to talk about the travel ban decision. Mostly, there's a lot of decisions that are pretty bad that are coming out of the court. The gay wedding cake decision was not a 5-4 decision, but still a bad decision. Um, and maybe I'll talk a little bit more on that later. But I want to focus on the travel ban decision, which was a 5-4 decision, and I want to read this one paragraph from USA Today, which I found very interesting. Um, Judges and legal analysts who defended the travel ban argued that Trump's words cannot form the basis for a constitutional violation. It takes too much interpretation, they said, to read anti-Muslim bias into an executive order for proclamation that on its surface is devoid of religious content. So on one hand, and this is a very frustrating thing for me. On one hand, I see their argument, but at the same time, like it just you have to defy all reason in order to come to that conclusion. So when you look at an executive order, I mean, the Supreme Court's job is to really kind of be strict about viewing things through the Constitution, um, and strictly, a legal basis. Um, However, I'm not an originalist. I think we need to kind of move past the Constitution, in my opinion. I mean, I think there's a lot of great things from the Constitution, but I think we should change a lot of it. And even writing a new one, I'm not opposed to. So that's kind of how radical I am. But so they have to view things kind of in that way, I understand. And so when they write these executive orders, when Trump did or whoever it was, they aren't saying in the order ban Muslims. They say it in a way that's much trickier uh, to to make that point. It's worded in such a way so that it's not entirely obvious, and words do matter in this case, because if you did have a religious discrimination like outright and it's like just written plainly, then yeah, that would probably not work. But if you do it in such a way, then you get around that. But still, I think it's complete nonsense. Um, because, like I say, you would have to just be denying basic facts that we could all look up and we all know are true. And I think it's basically comes down to three facts for me. I mean, there's probably a lot of other things I could point out, but so Trump said on the campaign trail that he wanted a complete shutdown of Muslims coming into the country. That's that's about as clear as you can make it. I mean, a complete shutdown of Muslims coming into the country, and that we're not supposed to read an anti-Muslim bias from that. Another thing, Rudy Giuliani was on Fox News, and Trump had called him out. I'm sorry, not called him out. Rudy Giuliani said that Trump called him up and said, "How do I do the Muslim ban legally?" And I don't think he necessarily gave away what that was, but I mean, it goes to show that yeah, it was a Muslim ban, and Trump wanted to know how to, get around the procedural aspects of it. Um, the other thing is when you delve into the first version of the ban, um, and this was pretty early on in his presidency when he tried to enact this. When you delve into the first version, there's an exception for Christian refugees. So, I mean, that seems pretty obvious that you have a anti-Muslim bias, and you're saying these countries that are all Muslim majority countries, we're banning people from coming from these places, except we have a special exception for Christian refugees. Um, I just think, yeah, this is a situation where instead of addressing the elephant in the room, which is Trump's racism and bigotry, we have to play these mind games and rationalize it according to the Supreme Court. Um, I think just a denial of common sense, and it's Orwellian, and because you're just basically saying that this anti-Muslim bias is not that, but we can point to clear examples of why that's what it was. I mean, his own words, and I just don't get why we can't use his own words. I'm not a legal expert, so I don't know um, what they're basing that on, but I would say it sounds kind of ridiculous. I think it violates the First Amendment because of freedom of religion. Possibly, in my opinion, the 14th Amendment, which is equal protection. Um, the Supreme Court did rule that Japanese internment camps were allowed. Um, so, it, and I believe constitutionally, the executive branch does have the say over who can come into the country. So that's the other issue with this, is whether Trump did have the authority to do something like this, like even if it wasn't um, banning Muslims, he can have a say over where they come from in the world. Um, I think again elections matter because he may very well have had the authority as president to do that, even though I would disagree. Um, I think no because of the First Amendment. We have a value in this country that was supposed to be a long held value, that we have freedom of religion. So we're not going to discriminate based on your identity, but based on your religion. Um, it should seem, given our history and the civil rights era and all these things, it should be obvious that we want to strive to not be discriminatory, but in this case, no, because we have a racist buffoon in the White House. Um, but yeah, I think they that he may have had the authority to do this, so the lesser of two evils does apply, and you have to, I think, vote for the Democratic candidate, especially when you're going against a person like Trump. Um, so I guess I'll touch a little bit on the gay wedding cake decision, even though it wasn't 5-4. So it's hard to say kind of what would have happened had Merrick Garland been on the court. Um, well, I would say that their decision, that they tried to make it a narrow decision by like not really validating the cake owner, the cake shop owner's First Amendment rights. They were saying that the Colorado Civil Rights Commission was going after him too hard, um, and based on his religion. So that's why they're a government entity, so they can't do that. Um, so my opinion is, if you want to operate a business that's open to the public, then you should be serving the public. And gay people are part of the public. Because this is a slippery slope argument, because this is opening the door, as we've seen GOP state lawmakers saying now, business owners should have the right to refuse black people, or an interracial couple, as one example. Based on religious beliefs, you can find religious beliefs that will justify that, and really, I mean, it gives religious people extra rights, because it just makes no sense. I mean, if I was, I'm, it's kind of a weird example, I guess, to bring up, but I'll say it to make a point nonetheless. Let's say I was a racist person, but I was not religious. If I was a secular racist person, um, if I refused to have black people in my shop, whatever, and I didn't cite a religious reason, then it wouldn't work probably, because I'm secular. But having the religious belief that is like this shield in our culture, where it's like a free pass to do whatever you want because we don't want to hurt your feelings or whatever. Well, I'm sorry, but you got to get over it. If you're a business, again, and you don't have to be open to the public, you can decide to only go based on individual clients, and refuse people in that way. But this business was open to the public, so once you do that, you have an obligation to not discriminate, in my opinion. Um, so I think that's where the ball really ends. It has to do with not letting the slippery slope get ahead of us, so that more discrimination is allowed. And I mean, this is kind of like a long-standing debate in this country, I feel like. We've made a lot of progress in terms of discrimination against people, but clearly not enough. The Supreme Court also decimated public sector unions, with another 5-4 decision. I want to read a little bit from CNN for this. The Supreme Court dealt a major blow to public sector unions on Wednesday in a case that could shake their financial structure and undermine their future stability. The justices struck down an Illinois law that required non-union workers to pay fees that go to collective bargaining and overturned a 1977 law that required employees to pay so-called fair share fees. The ruling was 5-4 along familiar ideological lines, with conservative Justice Samuel Alito writing for the majority in a case that highlights how the blockade of President Barack Obama's Supreme Court nominee has dramatically changed the legal and political landscape. It is hard to estimate how many billions of dollars have been taken from non-members and transferred to public sector unions in violation of the First Amendment. Those unconstitutional exactions cannot be allowed to continue indefinitely, Alito wrote. In a blistering dissent, Justice Elena Kagan wrote, "The First Amendment was meant for better things. It was not meant to undermine but to protect democratic governments. It was meant not to undermine but to protect democratic governance, including over the role of public sector unions." Reading from the bench, a move justices only do when he or she thinks a ruling is egregiously wrong, Kagan added, "There's no sugarcoating today's opinion." The ruling is another key example where the Senate GOP leader Mitch McConnell's move to block Judge Merrick Garland in 2016 after the death of Antonin Scalia has paid off dividends for conservatives. President Donald Trump nominated Neil Gorsuch, who has helped cement the conservative bloc on the court. It's the 14th different decision this term in which conservatives banded together to produce a 5-4 majority, in all of which there's a good reason to doubt whether a justice appointed by a Democratic president would have voted the same way. Okay. I did want to read a little bit more. This case could significantly hurt Democrats, said Steve Vladeck, a CNN Supreme Court analyst and professor at the University of Texas School of Law. This decision in particular will likely have ramifications on the ballot box, since it will weaken the economic health and political power of public sector unions who tend to support Democratic candidates more often than Republicans. So, this is like another way I feel like where they just try and disenfranchise people. People who don't have much of anything. These are like middle class people. I mean, think about who works in public sector jobs. Teachers, cops, construction. You go down the list. These people aren't powerful people, and the way unions work is everyone kind of has to be a part of it. And then the workers have rights, and this is why we have unions in the first place. And this is going to, again, I think this is just a sly way to get at public sector unions, except like they do it with like a certain plausible deniability. It's like, oh, we're not really killing them, but we're changing this rule that says that non-members have to pay in. Therefore, their power is going to dwindle. I think it's a poor decision. It goes against our history. I think we're regressing more and more under this administration and with this Supreme Court, and we're seeing the ramifications of it. I think we need stronger unions, not weaker ones. I feel like that should be obvious, but apparently not.